Welcome back to Time Served. The channel is against that, so you don't have to if you think you have heard and seen it all while court watching. I'm telling you, this case is so sickening that the victim's statements can only be posted for members only because it is so graphic that YouTube would throw me off. Anyway, as each member spoke of what this so-called man of the house had done, he only showed remorse when it came down to Judge Oda dropping a massive sentence. But honestly, it wasn't enough. Check out the uncensored version by becoming a member. The link is in the description. Don't forget to like and subscribe, and make sure to comment on this sentence. We'd love to hear from you. Let's roll, nerds.
Mr. Goodyear, on behalf of the state.
Judge, obviously, what you just heard is what I've described to you previously in this case from my interactions with the victims, throughout this entire process. And whatever charges the defendant was indicted for, whatever he ultimately pled to, can't possibly encapsulate the damage he's done to his children and to his wife. And it's profound. The reason why the plea was entered, frankly, was to avoid them having to go through the trauma of testifying. You've heard them describe the trauma they've already experienced as a result of the defendant, and that's the main motivating force why the plea happened. But Judge, I read the sentencing memorandum provided by the defense and the letters that were included, and I'll simply say that just because there is a veneer of someone that is a good person does not mean that there is not a private life that exists that others don't know about, and you've heard about what that was. He created private hell for his family and then put on a good face for the community. And I think that, I'm sure all those letters are well-meaning, but there are people that don't really have any idea of what actually was taking place in this case, or really just throughout their lives. Your Honor, in the defense sentencing memorandum, and I know obviously this court takes into account and follows the sentencing guidelines that exist for a case like this. These are felony fours. They're felony offenses of violence, so they're not mandatory or probation, excuse me. But if you look at the sentencing guidelines, Judge, and they talk about a couple of things that are very important. One, is he likely to reoffend? And two, is there any remorse? And when you think about whether he's likely to reoffend, first of all, you have the fact that this is a years-long pattern of abuse of multiple individuals. What plays into that, as you know, Judge, is whether he shows any remorse. And I know, Judge, you've had the chance to read the pre-sentence investigation, but I think some of it bears repeating here in the courtroom during his sentencing. There's a section of the PSI that is entitled Attitude. And the PSI writer indicated, throughout the course of his pre-sentence investigation, setup, and subsequent interview, Mr. Vanover made comments to this investigator to the effect of, why didn't they, the alleged victims, why didn't they come forward before now? Additionally, he made several jokes during both meetings to this investigator, in which he did not respond to his comments. He spoke with the Talbot House administrative assistant and conveyed he didn't understand why his investigator didn't react to his jokes because, one, he was not guilty, and two, he didn't do anything wrong. He further stated to the Talbot House administrative assistant that she, Ava Grace, the first victim you heard from today, that she was old enough to give consent, so he didn't think it was such a big deal. He then said, during his assessment, says he was not forthcoming or cooperative for the majority of the assessment. He reported regarding the charges, no, because if I say anything, they won't accept my plea deal. Clearly, he knows there's much worse things that he could acknowledge to Talbot House, but he refused to do so because he thought it would undermine the plea deal he ultimately received. I don't know, Judge, that I've ever read anything that more clearly expresses a lack of remorse than that. Not only does he not feel sorry for what he did, not only does he not accept responsibility for what he did, he is mocking these victims. So, Judge, I think that when you consider all of that, now, one thing I do want to mention about the sentencing memorandum from the defense, they talk about his medical history and his situation. I don't know if there's ever been any documentation provided for the court to verify what he's saying. But if you recall, Judge, early on in this case, there was a motion regarding the defendant's bond that was filed. And in that motion, very similar claims were made about how his medical condition existed and how it was affecting him while he was in jail. And then the state played for you in court videotapes of him in the jail walking around perfectly fine, belying the claims that were made in the bond motion. And I think we're having the same specious claims made in the sentencing memorandum as well. And Judge, obviously, if he does have medical issues that need to be dealt with, the prison system has a medical facility that can take care of all of his needs. So Judge, when you consider all of this, I think the only reasonable, from the state's perspective, the only reasonable sentence is a maximum sentence of 54 months in prison. We'd ask you to impose that, and I appreciate your time.
Buckle up, guys. Today we are diving into a courtroom case that becomes more disturbing with every passing minute. Right from the opening, the prosecutor paints a chilling picture of a man who allegedly hid behind a respectable public image while creating years of fear inside his own home. As the state explains why the victims chose a plea deal instead of reliving their trauma in court, the focus shifts to the defendant's alleged lack of remorse, making it clear that this sentencing is about far more than just punishment. It's about the lasting damage left behind.
Mr. Henry, anything from probation?
Nothing further than what we discussed.
Ms. Arnold?
Thank you very much, Your Honor. First, I would just like to again apologize to the court for my interruption. That was not intentional. To the complaining witnesses, our victims here who were speaking, certainly no disrespect was meant by that. In terms of additional comments from what's contained in the sentencing memorandum, I think that to indicate that there's not been any acceptance of responsibility, I think certainly cannot be true in light of us having been here after entering a plea. So to a certain extent, Your Honor can weigh that extent. There has been an acceptance of responsibility. In my conversations with Mr. Vanover, he has expressed sincere remorse for his relationships with his family. He has broken down in tears in front of me, in front of other members in the office. I believe that the catalyst, as the state indicated, the 2024 fourth-degree misdemeanor domestic violence to all of what we are now here for, was heavily influential in Mr. Vanover's understanding of his relationship with his family, himself, and his interaction with others. I know that there were a number of uncharged acts that were, to my understanding, not reported, certainly not trying to diminish them, but just indicating, of course, that we are here on the 3 offenses for which Mr. Vanover pled. I believe that there was a statement that was made as to drugs or alcohol being used to take advantage. I don't believe that there have been any prior allegations of that, and I'm not specifically aware that that was involved in the offenses, either of the gross sexual imposition offenses. At the court's time.
Mr. Vanover, you get the last word in all of this. What do you want to tell me? You don't have to stand up. You don't have to go to the podium. Whatever's best for you.
My world came apart September 23 when I was diagnosed with cancer. I lost my fire career to a cardiac issue. That was the last time me and my wife made love. And she said, we'll get through this together. But it was at that point in time that she stopped caring, stopped taking care of me. She sits in here and says that I was abusive. I didn't take care of him. I was demanding. I put him down. I was in a wheelchair and bedridden. I had to have my boys stand me up to use the bathroom. I had to have people wipe my backside when I used the bathroom. And them saying that I was still that mean type of person, I was not. And I'm sorry they feel that way. I raised my boys. You can ask anybody that I dealt with. I was always with them. I loved them. I cared them. I'm the one that sat there and watched Transformers was leaking repeatedly because he loved them so much. I stayed up till 2 or 3 o'clock in the morning when I was sick helping him get through his fire books. They've got the court believing that I'm a complete monster. They say I have no remorse. No, I do have remorse. But a lot of things that you've been told and the court's been told is an absolute utter lie. I did not lock my boys in the basement. I did not burn them with a torch. You want to know why I haven't had contact with my kids? It's because I had a mental break. October 24, 2024, I had a mental break. And her father, which is her attorney, said I had no remorse in Lebanon. It's because I couldn't think of anything. My mind was just so overrun, I didn't know what to say. And if I made jokes during the pre-sentencing investigation that I didn't say those things, it's because I'm trying to keep from getting so upset and worked up. Being told every week, I'm going to leave you, I'm going to leave you. The reason it broke with Garrett and him is he does have mental issues. The entire time I was sick, he would smack the bottom of my feet, and I had neuropathy severe, and it hurt. He'd come in and say, I wish you were dead, why can't cancer take you? And then 5 minutes later, he'd turn around, give me a hug and say, I love you. I don't know why I mentally broke, but I did that day. And I told the truth. I told the officers what I said. But I wanted them to get help. I've been going to counseling. I've been talking to my psychiatrist. I've been following everything what the doctor says. And yes, I can prove to you the prosecution of what the doctors are saying. I went 11 months with what they say I was in remission during when I was taking immunotherapy. The following month when I didn't take it, my CT scans came back normal and my Signatera test come back positive for cancer cells. I'm at extremely high risk for it to come back. In July, I have multiple doctor's appointments, blood work, CT scans, seeing my primary and seeing my oncologist to see where we go from there. I'm having issues from my surgery.
All right, guys. The courtroom now hears from the defense and finally from the defendant himself. While the prosecution describes a calculated pattern of abuse, the defense argues that he has accepted responsibility. But the defendant's own words quickly become the center of attention. Instead of directly addressing the crimes, he speaks about his cancer, family struggles, mental health, and claims that many accusations are false. As his emotional statement unfolds, viewers are left wondering whether this is genuine remorse or an attempt to shift the focus away from the victims.
So, Mr. Vanover, you don't have to answer this question if you don't want to, but I'm a little confused. What is it exactly that you are remorseful and sorry for?
Everything that I've done inappropriate, that they feel that I've done wrong, or what I've done wrong.
That's a child's answer, Mr. Vanover. I want a specific example of something in this case that you're remorseful for and sorry for that you think that you've done wrong.
The way I treated my wife and my kids. The inappropriate touching her. And just everything. My mind's just like everywhere right now. I'm remorseful for her. I'm sorry. I'm sorry if I was wrong, or I'm sorry that I did wrong.
Here's where we're at, Mr. Vanover. It's incumbent upon me to impose a just sentence in this case. And, you know, the knee-jerk reaction for these types of cases is to say, oh, you know, you should just add up the maximum penalty and impose the maximum penalty, and that's somehow justice, and it's not. And the reason for that is because it's an incumbent upon me to determine among the people who commit this offense and among the offenses that constitute this crime what the appropriate sentence should be. It's complicated by the fact that the plea arrangement in this case took the maximum penalty from somewhere in the neighborhood of 19 years down to about 4.5 years. And, I don't engage in plea negotiations, so...
Now the courtroom reaches the moment that changes everything. The judge asks one simple question. What exactly are you sorry for? Instead of giving a clear and direct answer, the defendant struggles to explain himself, offering vague responses that only deepen the court's concerns. In a powerful exchange, the judge makes it clear that true accountability requires more than tears, suggesting that the emotion on display is driven more by personal consequences than by the pain suffered by the victims.
So the court is going to impose a prison sentence in this case. On count 1, which is the GSI involving Celeste, I'm going to impose 18 months in prison. On count 2, for the assault on Lincoln, I am also going to impose 18 months in prison. And for count 3, which is the GSI on Ava, I'm going to impose 18 months in prison. This includes a mandatory period of post-release control. That means the adult parole authority is going to supervise you for a period of 5 years after your release. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence, or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. I'm going to give you credit for the 50 days that you have already done. You are required to register as a Tier 1 sex offender. I'm not going to impose a fine in the case, but I am going to impose the costs. Further, Mr. Vanover, I'm going to order that these sentences be served consecutively to one another. That means one after another, because a consecutive sentence is necessary to properly punish you, and your criminal history suggests it's necessary to protect the public, and no single sentence will adequately punish you for this. So that is a sentence of 54 months in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they will all be provided to you without charge. Is there anything else we need to do? Anything I forgot?
No, you are. Thank you.
Just, Your Honor, as it relates to the consecutive sentencing, I believe that as it relates to the statements on the record, Your Honor, for purposes of the findings that must be made, I know that you indicated prior criminal history shows that consecutive sentences are appropriate, but I don't know that I heard any other.
Yeah, I guess him being on probation, his probation is for an offense that's after that, so it wouldn't be his prior criminal history.
This is a decisive moment every courtroom case builds toward. After carefully explaining the legal reason behind the sentence, the judge orders each prison term to run consecutively, resulting in a total of 54 months behind bars. The courtroom falls into a serious silence as the consequences finally become real, closing a case marked by heartbreaking testimony and difficult decisions. If you found this breakdown valuable, don't forget to like this video, subscribe to the channel, and share your thoughts in the comments below. Thanks for watching, and we'll see you in the next video.